The sexual assault trial of Peter Nygard continues today. Nygard has been accused of using his position in the fashion industry to lure women and girls. The 82-year-old has pleaded not guilty to 5 counts of sexual assault and 1 count of forcible confinement in alleged incidents ranging from the 1980s to the mid-2000s. During defense cross-examination yesterday, jurors heard yes from a woman who said fear, shame, and concern that Nygard could derail her career prevented her from previously coming forward with her allegations. She's expected to be on the stand once again to begin the day. And for more on this trial, let's bring in a criminal lawyer, Kim Schofield. Thank you so much for joining us. You know, when it comes to the testimony of these complainants, no doubt any criminal defense lawyer is going to want to poke holes in the credibility of those stories. Talk a little bit about how that's playing out in court right now.
Okay, so what we heard from yesterday is this delay in reporting. So the concept of if it happens, you have an obligation to report it right away, and a negative inference can be drawn if you fail to do so. That notion has been dispelled in law recently. So the defense can still ask about it, but drawing a negative inference from the failure to report is no longer permissible. So the complainant can explain why, in fact, she did not report right away, and then it's up to the trier of fact with a certain direction that the trier or the judge has to give the jury on how to deal with that evidence. But we've also seen some attacks on peripheral facts. So in other words, what the garage looked like, what the unit looked like, where all of this is said to have happened in the bedroom suite. So the probing questions of circumstances surrounding is very important, because what they're trying to show is that the failure to remember correctly the outlying facts will go to the credibility and reliability of this witness's account.
Well, and oftentimes when we're dealing with sexual assault, there's so much trauma that is involved for victims that oftentimes some of those fine details might get blurred while trying to recollect something that happened many years ago. And I'm curious, you know, given the fact that, you know, we've seen so many of these high-profile trials of very powerful men who could very much make or break someone's career. Oftentimes, that is the reason why a lot of women don't come forward right away with, you know, reporting that they've been sexually assaulted. And I'm wondering if you think the jury is going to take that into consideration.
Oh, absolutely. But one of the things in this case for sure is also motive to fabricate. Is there a reason why either A, they're coming forward now, or B, why they may have fabricated this in the first place, whether there's any collusion between complainants or any influence over the complainants by articles in the media. And how does that play into potential civil suits or financial reward or financial gain? Because that certainly plays into this case, where we've heard that this complainant, at least, is part of a larger class action suit that has yet to be heard. So potentially some financial gain for this witness. Does that mean that there's a motive to fabricate? Because you are the victim of a sexual assault, and the Crown will say this, you're entitled to compensation potentially. So it's not a motive to fabricate, but rather just part of the process. And there should not be negative inference from a woman pursuing her right, which is to receive compensation for being a victim of a crime.
Kim Schofield, we always appreciate your time and perspective. Thanks for joining us.